In an unexpected turn of events, Gary Gensler has decided to retire from his position as a result of the U.S. Congress conducting an internal Twitter investigation during his tenure as chairman of the U.S. Securities and Exchange Commission, in which Gary Jenner made a veiled reference to his position. His intention to resign from his position, he expressed in a tweet via Twitter his gratitude to the agency for its 10 years of service and affirmed its team's commitment to providing assistance to exporters and investors. However, this seemingly innocuous message belies a deeper story of the tension and controversy that accompanied Jenner's tenure. This is especially true regarding his views on cryptocurrencies and ongoing legal battles with organizations like Ripple Labs, and the U.S. Congress is putting an increasing amount of pressure on Gensler to reconsider his strong stance. Legal action against a variety of cryptocurrency companies, most notably Ripple Labs, and its digital asset accusing Gensler of stifling innovation in capital markets, disagreements that arose between Gensler and some members of Congress over the regulation of cryptocurrencies eventually led to calls for his resignation, and this disagreement was the source of the disagreement that arose between the two groups under the impending elections in November and issues surrounding cryptocurrencies. There will be detractors and losses in court in the SEC lawsuits in cryptocurrencies, and the CEO of the SEC has been completely overwhelmed by the amount of criticism that has been directed at him regarding statements and even actions involving the agency's lack of competence, bias, and contempt for regulations. According to those familiar with the case, it appears as if the SEC has found someone who bears significant responsibility for the incident. YesAc lost money as a result of the Bitcoin litigation, and the portfolio severed ties with attorneys Michael Welch and Joseph Watkins during this month. The two lawyers were informed that they would be terminated from their positions if they did so. Not voluntarily resigning from their positions, the fact that they were involved in the legal proceedings surrounding the lawsuit involving the PACs in federal district court in Salt Lake City served as leverage following his highly critical comments made by Robert in March. Shelby decided to take action in order to punish the agency for abusing its position in light of recent events, in which the chairman of the Securities and Exchange Commission CC made a number of mistakes and was forced to write an apology after abusing his power to an unreasonable degree as President Gary, who gained notoriety due to his harsh statements that suggests cracking down on cryptocurrencies. He apologized, but biased agency staff would be trained to be more careful in situations similar to this one, Earl said, adding that the recent decision that held the SEC partly responsible for the costs of the actions was the tipping point, that 2 of the 5 elements will no longer be pressured to use cryptocurrencies, and there is a zero-tolerance policy regarding cryptocurrencies according to announcements made by agency commissioners, and this comes after the SEC approved an exchange-traded fund or announcement that the agency is actively working to restrict cryptocurrency and that something specific must change immediately. There have also been allegations that the SEC is looking for a scapegoat and making an effort to prevent cryptocurrency companies from abusing their power in XRP court battles by taking advantage of previous rulings. Due to the fact that an agency official had previously made comments about cryptocurrencies, and the agency did not intend to adhere to what were considered personal beliefs. As a result, after the new deadline extension, the SEC was made subject to the need to submit its bylaws on cryptocurrency trading by August 31st in 2021, and the SEC has received disclosure of the internal policy governing cryptocurrency. The purpose of the disclosure was to shed light on the SEC's activities and investigate how these efforts might impact litigation, according to people who were familiar with the purpose of the discovery proceeding that will begin on October 15th and will reach its conclusion. The conclusion in 2021 was to obtain information from professionals familiar with the crypto and securities fields as a result of the appeal filed against the previous ruling by Judge Netburn for the disclosure of certain government records. The date of publication of sensitive information has been postponed to 24th January 22nd. This review was conducted in order to better understand the situation and their professional opinions regarding it as a result of the SEC and Ripple Labs filing their initial motion for summary judgment. Significant progress has been made in the current litigation process, and Ripple Labs must now file its papers by February 17th, 2022 instead of September 17th, 2022, a shift from the previous deadline of September 17th, 2022. Following the motion's detailed description of the parties' views and opinions on the matter, the court accepted the brief filed by the Chamber of Digital Commerce on September 21, 2022. The the court heard the petition filed by the Chamber of Digital Commerce, an organization founded in the United States that promotes blockchain technology. CWBC and Ripple Labs filed their comments on the motions for summary judgment publicly after the November 30th deadline, and this was done in order to provide readers with a better understanding of the opposing party's position that the court permitted the publication of comments from the CW's brief on December 2, 2022, as a rebuttal to the petition was also included in the papers on December 2, 2022. The SEC requested that certain materials related to Heyman be redacted, and included these materials records the young man that was included in XRP, as well as any mention of them in court documents filed by Riverside Labs during the Heyman case. After a lengthy legal proceeding, the SEC filed a motion to keep both records strictly confidential. On June 12, 2023, the Heyman files became available for public viewing after Ripple and the SEC had a conversation about the importance of the document and how it could lead to changes in the case. The next step was to create records belonging to William Heyman, who had previously served as chairman of the Securities and Exchange Commission, that were accessible to the general public. This added a new facet to the ongoing legal struggle that will likely have a significant impact on the XRP case and the court's decision. For Ripple Labs, which was released on July 13, 2023, and was a victory for the cryptocurrency industry in its fight against us government regulators, despite the fact that Judge Torres stated that the company was not violating any rules by selling XRP on open markets, and Ripple was violating citing several regulations' lack of unique circumstances as the reason for Judge Torres' decision to deny the SEC's October 3, 2023 interlocutory appeal petition filed by the SEC on August 15, 2012. Judge Torres agreed that the SEC, the exchange, violated security regulations with every transaction made to institutional clients as part of their response to the appeal, which was filed on September 1, 2023, and the investment banker's declaration was filed until August. On the 18th, 2023, to file their appeal with the court, Ripple made it very clear that the SEC did not have the underlying legal authority to reach an informed decision